Hi everyone, welcome back to the video updates. It's Sade here. Today's video is going to discuss what the buyer's option would be when a buyer purchases property that was illegally subdivided or where some modifications were done without the proper permits from the county or from the city. So this question tends to come up, or let's say this issue comes up a little bit too often than I like. And so that's why I'm doing today's video, to just put a warning out there on things that you as the buyer should be on the lookout for, so that you have more of a recourse, even if a seller that's not very conscientious sells something like this to you and doesn't disclose fully what's really going on. So there are two scenarios under which this type of thing would happen. The first scenario is you're purchasing from a seller that did not know about the illegal subdivision or did not know about the unpermitted work that was done on that property. And in that case, of course, the seller is not able to tell you because that seller didn't know about it. The second scenario is where the seller intentionally omits to tell you that those modifications were made without a permit, or omits to tell you that the property that the seller is about to sell to you has not been properly subdivided, in the sense that the correct paperwork has not been filed and the approval has not been received from the county or the city. So those are the situations that we tend to get consultations on at the law firm. It's a little bit too common. So what you as buyer would want to keep in mind is that real estate transactions, they're private contracts, they're private agreements. So the law says that people are supposed to do A, B, or C when they're dealing with their own land. However, as private individuals, you can agree to waive your rights, or you can agree to look the other way. As long as your contract says that it's okay, then typically you don't have a lot of recourse. And what I mean by that is a few people out there, they sign a contract and accept the property as is, without doing any inspections, without asking for the survey, or without ordering a new survey if there were changes made since the old survey, or if the survey from before is way too old. And sometimes they also don't involve a title company to be able to do this transaction. And some people actually don't even hire a real estate professional. They just go ahead and sign documents without getting any consultations from people that are trained to be able to look at these things with keen eyes. So the caveat or the warnings that I wanted to suggest in this video would be that A, try as much as possible not to accept property as is blindly, unless you've already done quite a few real estate transactions and you've asked all the questions and you know the right questions to ask the seller and the right types of disclosure documents to insist on, even though you're taking the property as is. So the disclosure documents, they require the sellers to disclose certain things, and it depends on what kind of document you're using or whether you're waiving all the disclosures. So that's why I said it's important to have a real estate professional, because the professionals know what documents are out there that are available. You as buyer could present to the seller even when you're purchasing the property as is, without full inspection or without involving a title company. The danger in not doing an inspection is just that you don't notice certain things, but the danger in not asking for the disclosures is that the seller might be off the hook, because sometimes it's don't ask, don't tell. Because if you didn't ask them for it and you waived your rights as in you took the property as is, then most likely they're not required to disclose anything special to you. They're not required to give you the normal disclosures that a typical seller is required to give you when the property is not being accepted as is and waiving all those other rights. The other thing that you want to do is, if you see that you have a survey and you're not comfortable reviewing surveys, you need a realtor to help you look at it, of course, or you can do a consultation with a real estate lawyer, because the survey will sometimes show you that there have been changes to the property that you're looking at, and those changes were not inside the survey a while back. So that means there are recent changes, and you will then know that will trigger you to ask the questions of the seller, that were those changes done with full permission of the city or county. And then the seller will be put on the spot. When people are put on the spot, they have a higher duty, whether they are going to lie, whether they're going to feign or fake ignorance, or whether they're going to tell the truth. So when you ask directly, you have a better chance in the future, if they actually lie to you, to claim fraud or misrepresentation at the very least. So typically when I am doing these types of questioning, I would put everything in writing in one single email, and then I would insist on them to respond in writing rather than verbally. You could also do it through text messages these days, but I think when you have an email, it's a lot easier to keep it all in one place, and you have a trail of the questions and the responses, and it's very easy to use that evidence when you go to court, or if you go to mediation for this issue in future. It's very much easier to take a single email and the whole trail of emails showing that this person was being deceptive, or at the very least not checking their responses before giving you the response. So then you could get liability that way, or you could prove liability more easily the more due diligence that you, the buyer, did up front, and that you have some evidence of that beyond verbal conversations. So even if you are on the spot walking a property and you're asking questions like, oh, was that dock, that dock over there, was that approved? Did you get a permit before you built the dock? And things like that. Because I don't see it on the survey, and the seller says, well, yeah, we did. You're going to then go back later on to type up an email and say, yeah, I just wanted to verify again that the dock was permitted whenever you put it in, because it's not on the survey. So you put that in writing, and then they're forced to say yes or no. And that's something that's more concrete evidence. So keep that in mind when you're dealing with people and you don't have a real estate professional, or even if you have a real estate professional, some realtors don't realize that the best evidence is always to get something in writing. Okay? So the second thing that I wanted to mention is that the danger in taking the property as is without the title company being involved is that there might be title issues in future, or you might have issues with the boundaries that are shown on the survey, or with the easements that are not triggered because you didn't have a professional to pull up the chain of title and to also pull up any restrictions and records that are associated with that property. And in future, the whole point of title insurance, which is what the title company does, is they research everything before they would issue the title insurance. And title insurance is simply like health insurance. You don't use it unless you need it. And you typically don't need it unless there's an issue in the future that you discover later. So the title company will then cover your attorney's fees and whatever costs are associated, as long as that issue that pops up in the future was covered within the title policy. So that's why it's nice to always try to do that. If you're an investor or somebody that's just trying to save money, sometimes it looks very attractive to skip the whole title company process so that you can save money. It looks very attractive to not hire a realtor so you can save money. It looks very, very attractive not to talk to a lawyer at all so you can save money. But sometimes you end up paying a lot more in the back end if you do it that way. So because ignorance is very, very costly, and unfortunately ignorance of the law is never an excuse in the legal world. And so when you're doing as is, make sure you're 100% covered and that you're comfortable with that process. The other common scenario that I see is where the developer or whoever owns the big chunk of land starts to try to sell little pieces of the land without getting approval from the county to subdivide them into smaller lots. In some cases, the developer, or this is the person we're calling the developer, the person that owns the bigger parcel that's trying to subdivide them. Sometimes the person is not required to get county approval or city approval, depending on where the land is located and depending on who that party is selling to or transferring the property to. Typically, when you're transferring to your relatives, sometimes you're not required to do the subdivision. And if you're also subdividing into just a few lots, you may not be required to do a subdivision. So the law is very complicated and complex, and it's always better to talk to the lawyers as a developer. You talk to a lawyer that's comfortable with land development laws, and then you can do things the right way. But if you are the buyer and you happen to be my client that's consulting me, or you happen to be somebody that's consulting me and you happen to be the buyer, I would warn you as a buyer more than anything, because the seller is going to get money from you, close on the deal, and then you're stuck with property that you cannot really develop. And the reason you cannot develop it is the county is not going to recognize that subdivision. And so when you start to go out and get a permit for remodeling or permit for even just water access to the property, sometimes you get turned away and they tell you that the owner of the bigger lot is the one that can put in the permits. And that is going to affect you, of course, in the sense that it affects you currently, but it will also affect you when you're trying to transfer or sell to another party, because you then have to disclose to another party that there are issues that are unresolved. And the sellers typically don't want to come back and do the right thing. So you end up in litigation. You end up in court. And so that's why I think it's super important to get professionals involved at the beginning. Now, what if it's already happened and you've already signed the documents, you've already paid the seller, and now you're here today and you have land that you're not able to develop because the county just told you that it was illegally subdivided? The only thing you can do is get legal help. You can reach out to the seller first if you like and try to ask them about this situation, because hopefully you never knew about it before, otherwise you wouldn't have gone ahead with the deal. Or you could have negotiated a lower amount for the purchase price in anticipation of having to pay to be able to subdivide. And also knowing that the seller would help you with all the documents, because you do need the seller's permission and signatures to be able to actually subdivide. So if you hadn't negotiated it up front because the seller just simply didn't know or didn't tell you about it, then most likely you have to get a lawyer to review all of your contract documents and also send a demand out to the other side, and then try to do a mediation, which is an informal settlement conference where you have all the parties, and it's optional for people to settle. So if the seller still refuses to settle, then hopefully based on whatever type of contract you entered into, the lawyers might be able to sue that seller and force the seller to do the right thing. The reason why most sellers don't do it is it's just a lot of money to do the subdivisions, and it takes time, and they sometimes just want to quickly sell property and make money. So unfortunately, those will be your options. The thing I found that's even worse is that sometimes the sellers, the developers, sellers, they sell the properties, they try to sell little portions of that property, and they put people on a payment plan. So they sell it on an owner finance kind of deal, so you're still paying for property that is not even subdivided. So in short, if you walk away, you're the one as the buyer that stands to lose the most, because the seller might actually have power to do a foreclosure and take that property back, and also at the same time try to keep all of that money that you already paid towards the owner finance deal. And so I see that some developers actually do this in rural areas, or do this with people that are less sophisticated economically, because they can get away with it. And they do it intentionally. It's not even an accident. They intentionally go out there, sell to people that they know aren't able to pay cash up front, and they sell it on owner finance deal and get money for about 2 to 3 years before those other people realize, oh, I can't even develop this land, or I can't even make any modifications to my property. Then the seller would try to cancel that contract, find some fault, find a reason to say that you were late in making the payment, and then take the property back. So the buyer loses in that scenario, no matter what. So that's why we say get help up front before you sign on the dotted lines, especially if your purchase is going to be, more than $100,000. It just makes financial sense. So that's my quick review for today. Hopefully that kind of makes sense, and it helps you to advise your friends or relatives in the future, or even yourself, so that you don't fall into this kind of a trap, because it gets messy, it gets expensive, and even if you win, that seller might file bankruptcy and you just may never get your money back. So that's my overview for educational purposes. As always, thanks for watching, and if you like the channel, remember to subscribe, and I will be talking to you next time.